The broadcast is now starting. All attendees are in listen-only mode.
All right, good morning, actually good afternoon. So thank you for attending the webinar, Auditing Your Compliance Program to Respond to a Pandemic Environment. I'm going to introduce our panelists, but before I do, there's a housekeeping matter that's actually quite important to you, and that is, if you want CLE credit, you've got to do two things. You've got to write down the code that we'll be giving you during the course of the presentation, and second of all, you've got to put in your evaluation. Now this is the important part. If you don't like what we say today, please make sure you get the program straight. It's how to defend your first slip and fall. If, of course, you like what we have to say, it's auditing your compliance program to respond to a pandemic environment. You can hold your applause till the end because nobody can hear you anyway. So let's begin. Let me introduce the panelists. I'm going to start with Rick. Rick Small is not at Nelson Mullins, unlike the other three. Anyone who has been at a seminar dealing with compliance has met Rick. I think he attended every compliance seminar that I can recall over the last couple of decades. He really is the person who I think is most knowledgeable about compliance, and specifically in the financial industry. Rick has been at several key government agencies. He was at the Department of Justice. He was in antitrust. He was also in the organized crime strike force. He was also at the Board of Governors at the Federal Reserve. He was at the Treasury Department. I don't think he's missed a single agency that has anything to do with compliance. He's also made his way around the major corporations in private practice and working for entities including American Express, Citigroup, GE Money, Ernst & Young. He's been in the business for 35 years, and I think, as I said, he is Mr. Compliance. Working to my left, Bart is the head of our white-collar group at Nelson Mullins. Bart is a former assistant U.S. attorney. He's a former state's attorney, and he's also a former U.S. attorney appointed by President Bush. He has tried major cases, Fortune 500 company cases around the country. He is one of our most experienced trial attorneys. Matt is also in the same office in South Carolina with Bart, and like Bart and myself, a former government attorney, and so he knows things from the government perspective. He was an assistant U.S. attorney for 6.5 years. That time was spent in the white collar section. He has done major cases involving all sorts of fraud involving government funds. He was part of the state's Global Financial Services Center in the U.S. Treasury teams involving procurement fraud. I also was in government. I was in the U.S. Attorney's Office in New Jersey, at the Department of Justice, and entered private practice quite some time ago. Came to Nelson Mullins to practice with these guys and also do financial services, money laundering, and compliance work. So we've got a fairly full, robust program for you. So let's just jump right into it. Let's go to first slide. And so what we want to talk to you about is having a compliance program, but make sure that the theme of this program comes through. It's not enough just to have a compliance program. It's to have a program which responds to risk. And I think I've heard Rick many, many times say it's got to be risk-based. It's got to adapt. It's got to change. Your compliance program cannot be a static program. It's got to be, like our Constitution, a living document. Let's go to the next slide. And just as a refresher, looking at the folks who are attending the seminar, I think you all know that compliance program has to do these major things. First of all, most important, you got to comply with the law and the regulations. What may not be so apparent is your compliance program also may have to comply with industry requirements and third-party requirements, including any association in which you're involved. It's got to include corporate guidelines, protocol standards, and your compliance program has to include contractual commitments. And it may well be that your contractual commitments impose an additional layer or tier that your compliance program has to be responsible for, depending on your particular business or your particular industry. Next slide. So when we talk about a compliance program, there are certain components, and by way of refresher, you got to have internal controls. You have to spell out exactly what your protocol is, so that those who are employed by your organization, those who are officers, directors, independent contractors who may be governed by your internal controls, know what they have to do. One thing that's not apparent to most people is you got to also have training. You have to make sure your employees are aware of what they have to do, what they can do, what they can't do. And you have to have under many of the statutory schemes, an actual committee, an actual compliance officer who are devoted to making sure that people are doing what they are supposed to do under your compliance program. Risk mitigation often can be a separate committee. Many organizations will have a risk committee, which deals with insurance, deals with, should we go into this line of business? Is it risky from a financial standpoint? But risk mitigation can also include reducing the risk of noncompliance, reducing the risk of having a criminal violation, a civil violation, administrative, or a licensing issue. And then finally, the last big component, and it's one that very often is overlooked, is you've got to have a process for identifying what the violations are or what the issues are and having an appropriate response. It may be a hotline. It may be a mailbox that people can simply send in their notes anonymously. It may be an officer who will take complaints, but you've got to be able to identify the problems and be able to respond to them in order to have an effective compliance program. And so the one thing that we mentioned when we begin is that you've got to have a compliance program that is responsive, that it's reactive, that it takes into account changing circumstances. And so when we talk about risk-based, we talk about, is your geography different so that you may have to take into account special concerns or needs? For example, are you operating in a geographic region where bribery and corruption is more commonplace? Are you operating in a place where you've got new employees who are not trained? Are you getting into new lines of business that pose special problems? And so you have to have a risk-based program that takes into account your changing circumstances. The lesson to be learned from today's webinar is one of those risks is we're living in a pandemic. Compliance, why is it important? Well, the courts say it is. Slide 5, please. Don't have to read to you what the sentencing guidelines say, but I'll tell you, if you find yourself having to represent a corporation or you are employed by a corporation, the sentencing guidelines, if they're applicable to your conduct, will tell you in no uncertain terms, you better have a compliance program and make sure that it's effective both when the offense allegedly occurred and also when it comes time for sentencing.
And I would echo what Sam says about the compliance program. The first thing a prosecutor looks at when they're investigating a subject or a target entity is whether or not, first, number one, do they have a compliance plan? Because it's real difficult to not get prosecuted if you have no compliance plan. And the second would be, did the company or is the organization following that compliance plan? And as we all know from employment manuals, it's even worse if you have a compliance plan, yet you're just plain you're not following it at all.
That's a great point, Bart, because the best violation of a violation is you knew what you had to do, you put it in your compliance program, and you didn't do it. And so I think that point is worth underscoring. So what are the statutes that pay special emphasis on what your compliance program is? FCPA, Foreign Corrupt Practices Act. Are you in a position where your books and records are likely the subject of a violation because you didn't have someone who was keeping accurate books and records? Did you have a compliance officer responsible for making sure that people weren't giving gifts and gratuities in order to get business? Various labor laws, healthcare laws, and the big one, and maybe Rick wants to comment on, is the Bank Secrecy Act. It's applicable to what you do if you're in a financial institution. Rick?
Yeah, you want to go to the
next absolutely.
Sam, want to go to the next slide?
What was that, Bart?
Can we go to the next slide?
Yes.
Next slide.
Thank you.
The next one.
Yeah. So thanks, Sam. Yeah, I mean, Bank Secrecy Act fits right within your discussion now, and it is our Bible for financial institutions. We have very specific requirements that are laid out in the Bank Secrecy Act, which require us to have an internal program of controls, requires us to have appropriate training, requires us to have independent reviews, so audit, things like that, and then also requires the designation of an AML officer, BSA officer. But I think the salient points from what you were saying is that is a compliance program, and that's what we get reviewed on all the time. And that's the first thing that, if there's a failure there, will lead to enforcement actions. I haven't seen a lot of criminal cases, but you know better than me that we've seen a number of deferred prosecutions, which are in the line to a criminal case, and it really is a criminal case, but never comes to fruition because the companies are able to manage through it. But absolutely sets out exactly what you're talking about.
Claire, can we go to slide 7? In the banking area, also how you handle your documents, fair credit reporting, the Leach-Bliley Act require that you have a compliance program. You can't just take the stuff and shove it in the dumpster. You got to have a program that tells you, here's how we handle all of our paperwork. Here's how we make sure that personal identifier information is not disclosed to the public. And then I want to emphasize the point that I've now made twice, and that is going to slide 8. The program cannot be static. And going to the bold line at the end, they look at how the company's compliance program has evolved over time. And so one bell would be, has somebody reported a violation? And how have you responded to that violation? Has somebody reported an incident which requires further investigation? Did your compliance program handle that? How did it respond? Did it look into it? Did it sweep it under the rug? And so DOJ is telling us in as clear terms as they can, make sure that that program is, I use the phrase again, is risk-based and is responding in real time to what's happening in your company.
Yeah, and before I get into this next slide, I just want to go through one of the codes first. The first code we have is forget me not. That's forget me not. Yeah, but building on your point, Sam, you know, as a prosecutor, I'm sorry?
If everyone doesn't understand, you have to write that down so that when you're asked to provide the code for CLE credit, you'll be able to recall that.
Sorry.
No.
All right, so just going back to your point, though, about the importance of being able to show that your program has been evolving over time. As a prosecutor is opening up a case, what you want to keep in mind is they want to see that you've been proactively looking at potential issues, responding to them in real time, and that you're not just attempting to comply with your original compliance plan once the government comes knocking. If we go to the next slide, please. And so that underscores the need to have a compliance audit or review, because that really is compelling evidence later on when the government inevitably comes looking through what's happened. If we go to the next slide, we can expect that here with this $2 trillion that's come out from the federal government through the CARES Act. You can rest assured that they are going to come and want to know exactly how the money was spent. Hopefully they don't, but you have to assume that they do. If we can move on to the next slide. What we're talking about today really are two different programs, the PPP loan program, as well as the EIDL. EIDL stands for Economic Injury and Disaster Loans. And regardless of which program your loans are coming through, your clients' loans are coming through, it's important to know certain things under both of them. And that is, what uses are permitted, what are the bookkeeping and records requirements, and other programmatic requirements as well. And if you keep that in mind as you're developing a plan and conducting a compliance audit, you'll be in much stronger footing when you do have to inevitably discuss what happened with the government. Bart?
Yeah, so what do we learn from the past that are going to help us in compliance, particularly in compliance with the CARES program? To protect the program from fraud, you see that what happened was Congress, in the TARP case, if you go next slide, please. In the TARP case, that was a troubled asset relief program, you remember, and Congress allocated some $7 billion to it, to financial institutions. I know Rick is very familiar with the TARP program, but it also set up to provide oversight. It provided sort of a three-legged stool, which I call it, the Financial Stability Oversight Board, a Congressional Oversight Committee, and what I think is the most important for us today in compliance is a Special Inspector General for TARP funds. Next slide, please. Just look at the law enforcement results. As it says, you know, with government money comes increased scrutiny. Under TARP, these regulations were aggressively enforced, and that was by SIGTOP. That's the Special Inspector General. You see 389 convictions, most serving times in the penitentiary. The enforcement, even a decade later, continued to be robust. The government in fiscal year 2019 collected over $900 million. In fiscal year 20, $157 million. That's winding down, as you can see, but over time, it's lasted a long time. It was enacted sometimes in 2009, and you see just how long it has continued, because the government prosecutors who were also funded, as well as the agents and investigators, they made these things drag on. Maybe perhaps some would argue a little longer than they should have. So today's mechanism of enforcement under the CARES Act is the Payroll Protection Program, which we'll discuss a little bit, economic injury, the False Claims Act, and beware of the whistleblowers. You would always have to worry about whistleblowers in your business, particularly if you do work with the government. But in this particular case, anyone, any employee can blow the whistle if you haven't used the funds the way you were supposed to use the funds, the way you promised. And then the general criminal statutes relating to fraud, as we see with. Now,
so Bart, I have a question. So if TARP is an example of what we can expect, who's at risk? Is it the banks? Is it the borrowers?
It's actually the both. It depends on how. It's more so the borrowers, right, under the Paycheck Protection Program part of the CARES Act, because the borrowers, you have two issues that arise. The first issue is, did a borrower make any misrepresentations, or did they omit anything that's material on their application? So that's the first test. And second test, you ask, how did they use that money? Did they misuse that money? Did they use those funds for a purpose other than that purpose for which were designed? Such as the Paycheck Protection Program was designed to be used for paychecks, but it was also designed for operations for a company or an organization, to keep the lights on, if you will, to allow the utilities to continue to run. So if any institution, if any entity used the funds some other way, I know Matt is going to talk to you a little bit about some of the cases he prosecuted when he recently was a federal prosecutor at the U.S. Attorney's Office. And I can tell you a little bit about some of the people that have called me and I've met with that have misused the funds and some of the things that they've spent them on. So I think those are the two biggest things, Sam, is how you got the money. Were you honest when you got the money? Fill out your application, number one. And then number two, how you spent the money.
So Rick, are you seeing any enforcement action from your vantage point?
Yeah, so it's a great point, and I agree with Bart about the borrower being responsible. Here's the rub that I am concerned about, have not seen it yet. So under the Payroll Protection Program, the money is actually coming from the bank. So you apply to the bank does the underwriting, and then the bank also has a process to put in place to address when the customers who borrowed want to get forgiveness because that's part of the program here, that a lot of this money will never get paid. So the bank has to verify that the forgiveness application, as we call it, is meeting the criteria set by Small Business Administration. And then, of course, what happens is the Small Business Administration will fund the bank for what they paid out. So we're not at that point yet, but I have a lot of concerns. So what I think Matt's going to talk about a little bit is what we've seen recently on, you know, the guy that bought 10 Lamborghinis or whatever with, you know, with $1.5 million payroll protection loan. What we have not seen at all yet is any enforcement on banks for not doing their appropriate job, both underwriting and then the forgiveness. We are just in the early days of the forgiveness, but I've got this sense, and I think TARP's a great example, that at some point in time, this tide may turn because the government is going to understand the significance of the fraud that has come out of this program, and the deep pocket is going to be the banks. And so the deep pocket is the banks, and it's a very easy target for liability. So that's where I'm concerned right now.
Okay, and we have another affirmation code, which will be the final affirmation code for today. And that affirmation code is Pansy. I repeat, the affirmation code, the final affirmation code is Pansy. And next page, next slide, please. Okay, you see that Congress appropriated $7 billion in TARP, but it's $2 trillion into the CARES Act. So look at that contrast. We look at the aggressive enforcement, the long-term enforcement, and with the TARP funds by their Inspector General, and now you're going to have a pandemic Inspector General that's going to be looking at how did you spend $2 trillion in funds that were in fact either given to you or loaned to you. And so you see the fund, you see how it's $500 billion was to big corporations and $377 billion to small businesses, and then you go right on down the list. Next slide, please. And I think you can see they take a page, you would take a page from the TARP playbook, and that is that you'll see similar overlay. The most significant ones, again, you see the Pandemic Response Committee, you see the Congressional Oversight Committee, but again, the number one, the most significant to those of us in compliance is the Special Inspector General for Pandemic Recovery, because that is the one that will have federal prosecutors, either assistant U.S. attorneys or Department of Justice prosecutors, investigating with dedicated agents and auditors, either from the FBI or from the Department of Treasury, that will be investigating your institution, your entity, or your organization. So it's extremely important, again, to follow the rules and make sure you document the rules that you're following. Matt?
Go to the next slide, please. So we can count on is that the SBA and the Department of Treasury will conduct investigations while borrowers whose loans exceed $2 million, and that's going to happen regardless. But they're also going to conduct reviews in situations they deem appropriate. Exactly what that's going to consist of is unclear still. However, I will tell you that as recently as January 4th, I was at the attorney's office, and a number of these cases were already coming through, and it was a very concerted, organized effort to prosecute cases relating to the CARES Act. If you go to the next slide, please. We said here we've seen a huge uptick in the number of enforcement actions, and really what prosecutors and investigators are going to be looking at are some of the really simple pieces of these loan applications, like number of employees a business has. So we saw a number of cases where people were just adding children, family members, cousins, whoever, fake people, to inflate the number of employees, increase the amount of money they could get. Same thing with the way they were using the funds. We had just some crazy examples coming through, just some low-hanging fruit where a truly small business, less than 10 employees, has nothing to do with planes, and the owners bought a plane and a yacht, and is completely unrelated to the type of business that they ran. And that's sort of easy low-hanging fruit there, but you can rest assured they're also going to start digging in to see where people have conducted the fraud in more nuanced ways.
And let me chip in here. I've had several clients that have come see me, and one of the first was a client that owned a restaurant chain. It was a small restaurant chain, 5 or 6 restaurants, but he created another restaurant sort of out of a bolt of cloth, out of the blue, and claimed 21 employees for that particular restaurant, which was listed as a LLC. And so when the government came looking, when those investigators, when the U.S. Attorney's Office and the FBI came looking, of course, they saw that there was no additional restaurant and there were no 21 employees. Well, that's the easiest case in the world, as Rick, Matt, or Sam will tell you, to prosecute. It's the difference between black and white. It's either there or it's not there. I had another one that used the money for every purpose you can possibly imagine, but for the purposes of payroll or for operations. And that is one of this particular client funded her 401k. She bought a golf cart, and she made other frivolous expenses, really, and had very little at the end of the day to show for it. So again, they look at the two things: the application, did you lie on the application, the number of employees, or the use of the funds? Did you misuse the funds or use them in a way that was not intended by the CARES Act?
And I would just, I'm sorry, Sam, I just want to add, lest anybody thinks that the government's not figuring this out. I mean, you've got these cases. How the government's getting these cases right now is the banks are ratting the customers out. So we have obligations to identify and report suspicious activity. That is how every one of the cases that I'm aware of now, the criminal prosecutions to date, have started, because, and you're going to talk about that in a minute, the SBA hasn't really caught up yet on how to look at these things. I mean, they say they're going to, but they haven't been able to get ahead of it. So it's all the banks. The banks are ratting everybody out because we've all got these obligations, and we know that we will get second guessed if we have not appropriately reviewed and reported when it's required to report.
So, Rick, that's an interesting point. There's been a lot of talk, for the last several years about banks over-reporting on SARS because they want to essentially protect themselves by saying, look, we file SARS all over the place, suspicious activity reports. Is that happening with the CARES Act? Are the banks overreacting and essentially, and of course, we're not talking about your bank, which does everything correctly. We're talking about in general. Can you expect that the financial industry is going to be more inclined to file SARS, looking for things that perhaps may even be borderline or perfectly okay?
Yeah, absolutely, and not my bank, of course, but I will tell you that on balance, so just to what Bart was talking about with, for example, number of employees, or whether the funds were actually used for capital expenses as opposed to capital improvements. And there's some challenge around whether capital improvements is actually capital expenses. And then, so whether it's allowable, absolutely banks are taking at least in terms of meeting our suspicious activity reporting obligations, filing the suspicious activity reports, because we'll let the government figure it out. We don't want to be second guessed later on something that somebody with 20/20 hindsight is going to say, of course it was bad and you didn't file on it. So yeah, absolutely. I don't know if I would say it's over-reporting, but I would certainly say it is, on balance, anytime there's a question, file.
And that just goes back to the need to show that you have an active and an evolving compliance program. And if you're not reporting, that's certainly a red flag. And so I just imagine that. I know I was in charge of the SAR review team before I left the U.S. Attorney's Office, and we started seeing them flood in. And it adds more work, but at the end of the day, you get more information too, and it's better for investigators. But with regard to Sorry, I thought someone was going to say something. With regard to employees, one of the things that you really should do with borrowers and is conduct training, compliance, so that they know and they're aware that the government is looking into what's happening with this money. I think part of what happened with the shutdown, the pandemic over the past year is probably a lot of people could be lulled into thinking that sort of everything has shut down, but the government has not shut down. Investigators are looking into everything, and so it's important for the employees to be aware what their obligations are, and then how to report things up the chain. And so some of the things you can do is set up hotlines or other mechanisms for reporting issues as they arise. And so at the end of the day, one of the most important things that you ever need to do is document everything and show why the borrower applied for the funding. They've got to be able to back up how they're certifying different statements in in their application and how the funds were actually used. And the more you can document, the more you can show, the safer you're going to be.
Next slide, please. So what precautionary measures can you, as an institution, as an entity, take to sort of hold government investigators at bay and be able to justify what you've done? I think the first thing, I tell clients this all the time, you want to, and I tell friends as well in the business community, set up a separate account for your PPP proceeds. Do not have it go through your operational account. And I know Rick would say the same thing. I'm really interested, Rick, on your comment on that. Do y'all ever advise clients when they come into a bank that they should set up a separate account?
We do not. So I totally agree with you, by the way, but we don't believe we're positioned to force a client to do that. And we actually had a lot of contact with the Small Business Administration early on about, for example, sole proprietors that are getting a PPP loan. Do they need to have a business account, or is it a problem if they put it into their personal account? Because a lot of sole proprietors just have a personal account. And we were told that it doesn't make a difference where that money goes. Now, one of the things we have done is, so we had a lot of customers that were just what we call lending customers. They weren't deposit customers. We did require them to open up a deposit account to put the proceeds of the loans in. That is as much a compliance reason that gives us the opportunity to do a little more due diligence, as well as a business reason, because why shouldn't we get the float and use of the money before the client uses it? So it made a lot of sense. But I agree with you, Bart, and there are other banks that I have benchmarked with who the start of their process to determine whether or not there may be suspicious activity is to look at whether the money came into a business account or a personal account.
So commingling funds, as most of us know, particularly in the legal community, is never a good idea, because it makes it difficult to be able to show what was spent properly and what may not have been spent properly. So you want to set up a separate account, and you can follow every check. You can follow the deposits you can follow the deposits in, and you can follow the checks out. And then I think it's important to monitor for ongoing regulatory guidance. That is, since the CARES Act has been passed and was signed into law, Treasury and SBA have provided updated guidance for those borrowers who have sought to take advantage, rightly so, of the program. And so I think you need to be checking on that guidance and staying on top of that guidance, or have someone do it for you, whether it's a compliance officer or whether it's legal counsel, but someone within your organizations that's responsible. One person that's designated as having the responsibility for monitoring the guidance that comes through from the SBA on the CARES Act. And then I think you should consult outside counsel, and consult outside counsel that deals with this particular area, particularly a business lawyer or a financial services lawyer. Because if you consult me, I deal with problems after they've already arisen. Matt and I both, we defend white collar cases. By the time we get them, they're usually a mess. Okay, and we're not as good. We're not as equipped really to give advice on the front end. Now, we can tell you what not to do, but to tell you what to do is sometimes a little bit more difficult for us. But here we can tell you, you want to be careful, you want to set up that separate account, and then you want to monitor for ongoing regulatory guidance and consult outside counsel with the experience in the financial sector. And so I think that's how you stay on top of and avoid, the old ounce of prevention is worth a pound of cure. And never is that adage proved truer than with the pandemic relief that's provided by the government. Remember, $2 trillion versus SIGTARP's $7 billion.
The idea of hiring outside counsel is often very unwelcome advice because it means an expenditure, and sometimes there's a bit of counseling of a client. So, how do I sell to my board of directors that I'm going to spend money on outside counsel advising us what to do? And what I tell people is think of it as a premium on an insurance policy. And that is what you're doing when you're having counsel bless your operation, bless your compliance program, bless the way you're spending that money. You are building in a defense just like you're paying a premium on an insurance policy, and it's money well spent to make sure you don't get into trouble. And if somebody is looking critically at you, if Matt were back in government and looking at your operations, you would say, advice of counsel. We ran it by counsel, and very good, smart lawyers told us this is the way we should have done it, and this is our expenditures, and it was proper. So for those in-house, think of it as essentially a premium on an insurance policy against a more serious issue.
Sam?
So coming back to our main theme, we have a pandemic. We've got a very changed landscape here. We're now doing operations business that we didn't do before. What does that mean for our compliance program? It means that you've now got to audit it. You've got to look at it. You've got to go take it out, shake it up, dust it off, and say, does it really address the risk that we're now facing? What are the risks? The risks are that some very smart prosecutor, some very smart accountant, someone at the SBA or someone at our bank is going to look at us and say we're doing something wrong. Make sure your compliance program is responsive to your new business model.
Yeah, and I'd like to add to what Sam has said. One of the top priorities right now within the Department of Justice, including the U.S. Attorney's offices locally, as well as the FBI nationally and locally, is pandemic fraud. So it's a top priority for them. And you're going to see young prosecutors and prosecutors that are maybe perhaps trying to put a notch on their belts, and agents aggressively enforce the law when it comes to these, and aggressively investigate these cases because it is important to the Department of Justice, and prosecutors and agents do get what you would think of as perhaps extra credit, if you will. So it's very, very important to monitor and remain in compliance.
Now, on slides 22 and 23, it's simply to emphasize that both DOJ and the courts are going to be looking at what you're doing to update your program. We don't have to go through them line by line, but it's the factors that will go into should a prosecution be brought. If not a prosecution, should a civil proceeding for forfeiture of improper proceeds be brought? Should there be a debarment or other kind of regulatory or licensing proceeding? And so DOJ and the courts are going to look at your compliance program in making that determination. And just on slide 23, the point, you turn to 23, the point is, again, I can't emphasize it enough, it can't be a static program. It's got to adapt to changing circumstances. And these quotes here are taken right out of the U.S. Attorney's Manual. This is the Bible that Matt used to use and Bart and I used to use when we were in government. It tells you what you can do, how you should look at the compliance program. And the answer, it's got to adapt, it's got to change, it's got to evolve. And right now is the time to do it.
The government uses terms, the government agents and auditors particularly use terms that they want you to have a robust compliance plan. And you ask what that means, it means just what Sam says. And I know Rick and the financial institutions have been dealing with the years under the Anti-Money Laundering Act. You know, they've got to do their due diligence. This must be robust. That's the term that the auditors use, because they want to make sure, as Sam has said, that you're updating it, that it's changing, it's evolving every day, and it's moving forward as circumstances change. So it's got to be adaptable, and you've got to adapt it to the changing circumstances. So it must be updated repeatedly and periodically.
So
keep in mind that, I'm sorry, Sam.
No, go ahead, Matt.
You know, when prosecutors are taking a look at cases and, you know, agents come to them and they pitch the cases, they've got to make decisions about, you know, how to weigh different things. And one of them is just time and resources. And if you're looking at two cases, and one involves a company where they have a robust compliance program, another one doesn't, and it's just a piece of paper they're not really following, it's going to be easy to make that decision. So it's just important to just keep in mind you're sort of building up a wall, so to speak, so that, you know, it's making it that much less appealing for a prosecutor to move forward with a case.
Yeah. As Sam said, that with paying the lawyer, look, you can look at it as a premium on the insurance policy, and it's much the same with taking the time and taking the energy to prepare, you know, to have a compliance officer who's actively updating and continually updating the compliance plan as its response to this change in circumstances.
One thing that I always thought was your compliance program relates to your own operations. You're looking at what you're doing and making sure that you're dotting your I's and crossing your T's. But it also applies to who you're dealing with. That is, are you dealing with other parties who are engaged in some kind of criminal activity or regulatory offense? And should you in your compliance program be doing something to monitor that? I'd be interested in hearing from you, Rick. What do banks do in terms of looking at their customers to make sure that their customers are not engaged in improper use of the CARES Act or other activities?
Yeah, and we actually have some of that, Sam, on the next slide, which talks about evaluating the risk. And so in the banking sector, we spend a lot of time and have very detailed methodologies to look at our customer base. We look at the type of customer, you know, industry. Are they individual? Are they for a business? What type of business? How are they registered? Are they in the marijuana business as opposed to making cars? Whatever that is. We look at geography. So we look at where the client, their customer is located, and where transactions are going to or have occurred if we have some experience already with the customer. We also look at the types of products and services that we are offering to the customer. So that's a little bit different if you are in the business and you're doing this type of risk assessment. But we find, for example, having a deposit account, it may be a little bit more risky than lending money, because we're taking money in, which ultimately somebody could say is related to fraud or money laundering. When we're lending money, it's our money to begin with, obviously, and we've hopefully done the appropriate due diligence and underwriting. So we look at that. And then we have a couple other factors that we look at specifically on the banking side: how we acquired the customer. Did we pick up the customer online? Did they walk into a branch? But we have an extensive risk assessment process for our customers. And it's interesting because it is not required by regulation, which is something that I've been kind of yelling about for years, but it is clearly an expectation. And every time you see a significant enforcement action on a financial institution for failures in the AML-related space, one of the causes is that they didn't have an appropriate risk assessment process.
Yeah, I would add that with the compliance program, if you have more than one location, for instance, or you have different sections of a larger organization or different groups within that organization, you must make sure that the word has gotten out so that when you do have a problem, it's identified immediately and that does not become systemic. Because one of the things that prosecutors, agents, and auditors look at in the evaluation of whether to make a case, to bring it, or to not bring it, is whether the problem is systemic. Because if it is systemic, it makes it a much easier case for prosecutors to prosecute.
And one of the things we talked about before was responding to an incident. That might be one of the most important things about your compliance program is how well do you do when something is brought to your attention? And that raises some very delicate issues. How far up the management chain did you look at things? Did you examine whether the CEO was involved? Did your compliance officer look at whether the board was aware of the situation? That's one sure way to find yourself a new job is to accuse all of your superiors of engaging misconduct. But a compliance program means you've got to look at an incident and try to figure out what happened and who was responsible for it. One of the things that DOJ and all of the U.S. attorneys look at is accountability. Does your compliance program take into account accountability and who is responsible for actions and what happens when they do something they shouldn't be doing?
Yeah. And as Matt would say, just as a recent federal prosecutor, prosecutors always want to go and look into the C-suites. If they can get that scalp of someone in the C-suites. So you look out for CEOs and CFOs and COOs, they have to be extra careful. And those of us in compliance, need to be especially careful and especially instructive to make sure that they understand the compliance plan and that they in themselves are complying with the compliance plan. The worst thing you can have is to find that you're having an investigation and your CEO, while he may be preaching compliance, is not being compliant himself and not following the rules.
And I think actually sometimes it's a very nitty-gritty analysis. You had a training program. Did your CEO take that training program? Did your board members take that training program? Or is it something that you left for the folks who, are basically line people at the lowest levels? You've got to really show that you've implemented it up and down the chain of command. So what do you do now? We're in a pandemic. You got a lot of money. What do you do now to make sure your compliance program is effective? Do you hire an accountant? Do you have your normal outside auditor look at it? Do you hire a law firm? Do you look at it yourself and do self-help? What's the best advice we can give the folks who are attending the seminar as to how do you dust off your compliance program and make sure it's effective? Well, one thing is make sure someone does it. whether it's your outside auditor, whether it's your outside counsel, whether it's your inside GC, whether it's your compliance officer, make sure someone is going to look at it in terms of, hey, did we get a vast infusion of cash and how is it being spent? And what are we doing to make sure our books and records dot all of the I's and cross every T, to actually look at your compliance program and shake it out. Any other thoughts about what we would do to engage in a review of our compliance program in this particular environment?
Well, Sam, I would just add that, again, if we're coming back to, I bucket it as CARES Act funding, whether it's the PPP programs or the economic injury programs, the other auditing factor is that banks are doing that. So as I talked about before, and we've been talking about, if we're making that PPP loan, we've asked some questions. We're not asking specifically about our customers' compliance program, but we're asking questions that should get at whether or not that particular entity has an appropriate compliance function. And then we are looking, even if the customers are not asking for forgiveness, we're still looking at evidence as to how the funds were used. So from a bank perspective, if you're asking for forgiveness, there are a lot of questions that come with that. And so that's your sort of second chance at getting your own auditing correct, because you should already know what was happening with those funds and how they're using them. Even if you're not asking for forgiveness, as I mentioned earlier, with our requirement to look for and identify suspicious activity, banks are certainly looking at output of the funds. So, nobody should be surprised that a bank has the ability to look at everything that's coming in and going out of the account. And if it's not lining up to payroll or some type of capital expenditures, there are going to be a lot of questions coming from the bank.
So let's go to tab 27. I would urge folks to think creatively about their compliance program and what are all the things that can go wrong. And I think that the experience in New York is a great example of something you would not have expected would be a pandemic problem. And it turns out it was a New York State compliance issue. Were there compliance folks thinking about, are we reporting the correct number of nursing home deaths? And now we find the governor is in a very difficult position because the allegation is that the simple reporting of information was wrong. For maybe you're not the governor of New York, but you're running an organization that is involved having a reporting requirement. For example, reporting to banks, that presents special problems. Reporting to the government presents special problems. And your compliance program should be looking at every time you have a reporting obligation. And are we looking at that and making sure that we are reporting correctly everything having to do with our pandemic related risk? One other point on that slide is SEC risk disclosures. Well, you've got a lot different risks now that you never thought about. One of them might be that 2/3 or 3/4 of your workforce is working at home and using their computers. And you might have cybersecurity problems that you didn't have before. If you're a publicly traded company, are you thinking about your risk disclosures and whether or not you are adequately telling your investors about all the risks that you're now facing, which you didn't face 13 months ago? And so I think in talking about your compliance program, you got to think about what are risks that we never contemplated when our compliance program was put together 13 months ago that now are very much real and serious risks.
Yeah, and I would add another great risk, and that is if an employee does raise an issue, whether it's done formally through the formal filing of some written document, some written complaint through the compliance office or otherwise in the chain of command, or whether it was done informally by just mentioning something to the compliance officer or to someone in their chain of command, is that taken seriously? Is that followed up on? Is it addressed? Because again, if it's not, it could be a big problem. And I defend a lot of whistleblower actions, as does Matt and as does Sam. And what we see in whistleblower actions all the time is time and time again, the person that becomes a whistleblower, they may be a sort of a difficult employee or a disgruntled employee, but they also raise legitimate concerns. And just because they're an abrasive employee or a troubled employee, when they raise something that might be really a problem, you better take it seriously, because otherwise you're setting yourself up for a whistleblower situation. On the other hand, if you want to sort of inoculate yourself, if you use a popular terminology these days, and that is, you go to your compliance plan, you've got it set up, it's robust, and you're following it. And when employees or anyone else raises a compliance issue, you're addressing it.
Well, following up on inoculation, I think we might say that compliance program is the vaccine against government enforcement. There we go.
There you go. That was a lob ball, Sam.
Just quickly, I would also point out that health is now a risk that you didn't face 13 months ago. Does your compliance program make sure that your workers are healthy and safe? Do you have a policy which is consistent with local law and whatever your jurisdiction is? If you have to wear masks, are you requiring that your employees wear masks or isolate? Are you making sure that workers who are ill are not coming into work and infecting others? Because if you are, you now have a risk to the health and safety of your workforce, and your compliance program needs to react to that and adapt to that. Any other thoughts, or should we move to questions? Are there any questions? I think if so, you can raise your virtual hand. Well, if not, from the four of us, we'd like to thank you for attending the webinar. We've enjoyed it. We hope you have as well. And remember, if you don't like it, it's how to try your first slip and fall case. But if you do have any questions, feel free to contact any of the four of us independently, and happy to to follow up on any questions. Remember, you're going to get your evaluation. You would need to fill it out for your CLE. And we thank you for attending.